someone who's got political, leanings, you're an Occupy person or whatever, you're a Republican, I don't know. They can use that to create that type of thing. So if you're somebody who does want to engage in activism, for example, and you want to do it in a way where your privacy is respected, I mean, the sad truth, the most privacy protective way to protest in today's modern age is to leave your cell phone. And I hate to say that because I work for the EFF, I love technology, but I mean, if you want to really truly be as privacy protective as possible, you got to leave your cell phone at home. If you don't want to do that, and a lot of people don't, there are other ways by which you can really be careful with how much data you store on your phone. If you're going to go to a political protest, you may want to bring like a dummy phone that just that doesn't have any sense of data. Maybe you delink your email account, or you delink your cloud storage. And the reason you have to think about doing those things is because don't forget. Well, maybe not don't forget, but I didn't tell you this, which is why you probably didn't know this, but if the government arrests you, if a police officer arrests you, they have a right to search your person to make sure you're not carrying any contraband or weapons or drugs or whatever. Well, some courts have said that goes as far as allowing them to search the actual contents of your cell phone. Okay? In California, where I come from, if you get arrested for a DUI, they get to search your cell phone. On the spot, without a search warrant, without any reason to believe that there's any evidence of a crime on your cell phone. They get to search it, period.
There was a case about that.
Yes, there was a case in, there's been a number of cases on this. There's a decision in Colorado, said the same thing. Georgia said the same thing. Ohio said the opposite. No, you can't do that. Washington State said that cops could. So, I mean, it's a mess. So, again, if you're somebody who engages in that type of activity, you have to be very, very careful with what you take with you because you open yourself the possibility, the cops arrest you for disorderly conduct because you change yourself to a wall, you're going to get a citation, you're not even going to go to court, nothing's going to happen, but all of a sudden now they know everything about your personal intimate details of your life, and that's a problem. Yeah, sure.
Sorry, I just have two more quick questions.
Sure.
Well, to what you just mentioned, it seems like what's lacking is this a federal statute that would govern, that would help, sort of guide these local issues. Considering the cases that you just mentioned, in states they're ruling state by state and case by case. So maybe we have some sort of federal statute that was a bit stronger than what was passed in 1986 that really clarified it. Further, like what is allowed and what is not to be gathered. So my point is that you had mentioned that there had been legislation before, and I was just wondering, do you remember what some of that legislation was?
Yes. So there are really three different proposals at the federal level. The first is called ECPA 2.0, so ECPA 2.0. And this is basically a proposal to just overhaul the Electronic Communications Privacy Act and get rid of the 180-day distinction. And it also includes protection for not just contents of communication, but also documents stored in the cloud. It was introduced in the House. I don't know how far it's going to go. The second proposal is a proposal by Senator Leahy of Vermont, who actually was the one who authored ECPA, and he actually does a lot of that privacy stuff. And he wants to also update ECPA to get rid of the 180-day loophole. Now, the problem with his proposal is that some amendments have been floated, and one of those amendments would basically allow the government would allow administrative regulatory agencies of the government to be able to get email and other contents communication without a search warrant. So what it means is, like, the FBI couldn't do it, but the SEC could. And that's a really arbitrary, stupid distinction because the SEC and the FBI, they all are the federal government, period. So we don't like that proposal. The third one is called it's a little different, it's called the GPS Act. And this one was put out in 2011 and hasn't gone anywhere, unfortunately, even though it has bipartisan sponsors. It has Senator Wyden, who's a Democrat in the Senate, and then Representative Chaffetz, who's a Republican in the House, sponsored it. And it doesn't talk about electronic communications, but it does propose some pieces and amendments to ECPA that would require search warrants for government to get access to your location information, like electronic location information, like the cell phone tracking records or IP addresses that could reveal where you are. problem is unfortunately, we have a DC that's very dysfunctional, and they don't really like to do anything. And even though there's actually bipartisan support for fixing the problem, it's not high on the priority list. I think maybe the Petraeus thing will change that now that like every major newspaper sitting here talking about the fact that the FBI read 30,000 pages of emails in a sex scandal, which is, we can sit and talk all day about why they're even doing that, but hopefully we'll highlight that the law needs to be fixed. Let me get to some other people and then, yeah.
I'm just curious, do you think that some of the lack of movement regarding this legislation comes from the disconnect that the generation currently holding these seats has with, with social media, with cell phones, because they didn't grow up in that same kind of bubble that all of us here have, And so do you think that also in the next 20, 30, 40 years that we'll see more, a bigger push for this because the people that are coming into power will have grown up within a...
Absolutely. I think that's the number one problem. When you think about court decisions that decide cases, like to become a judge, you've had a long, successful career as a lawyer. The judges are old. They're in their 50s and 60s. We had a case, EFF had a case where we wrote a brief to a court in Maryland, federal court in Maryland. This guy was a very well-respected judge, but he was in almost 70. He did not know what Twitter was. We have to explain to him what Twitter is. And, you can explain Twitter on paper. It's a microblogging site. You can post updates that are 140 characters less, but that doesn't really capture the essence of it. And that is absolutely a problem. In 2010, the Supreme Court got a case where they had to decide whether people had a reasonable expectation of privacy in text messages. And it wasn't even really text messages. It was actually messages to a pager, like a pager, the little things you clip when you were this is when I was in 8th grade, right? The little pager, and it beep beep, and then you look and you're trying to decipher the code. And you know what the Supreme Court said in that case? And I would note it was Justice Kennedy, who's in his mid-70s. He said, the court has to be very careful when we interpret how constitutional principles apply to new technologies. He's talking about a fucking pager. That is a problem, okay? So the courts don't even want to touch this because they don't understand the technology. Most of the lawyers, I think lawyers are now starting to understand the technology, but it's really this generation of people who grew up with the technology. I got my first cell phone when I was in college. I'm not even that old, I'm 29. So I got my first cell phone in college, but there are people who are going to have, their first cell phone they got in 8th grade and it was an iPhone. So when that generation grows up and they can explain technology to courts or they're the ones who are creating technology and they're thinking about these things, that's great. And for a long time, people weren't thinking about these things. But I think when the SOPA-PIPA fight was dragging on, we're starting to see now this generation of people saying, hey, you know what, I actually do want to be private. I do want to have the ability to speak freely on the web. And we're starting to see movement, but then again, you see Congressman Leahy proposes a bill that makes 0 sense. So that's part of the problem, but I think there's a solution coming, and it's you guys. Yeah.
All right, 2 questions. On the subject of privacy with the third parties, right? Stuff against third parties. Is that only an electronic thing, or for example, if you use a courier service, because that's also a third party, are you waiving your rights to privacy, and can deleted emails be subpoenaed?
Ooh, deleted emails, that's a good question. I would think that deleted emails they are probably do not require search. They probably can just be obtained with a subpoena, but I'd have to think about that. On the third party issue, the third party doctrine has generally been used when it comes to business type records. In fact, the 2 Supreme Court cases where that doctrine really kind of was spelled out were one case was involved banking records that a customer had with the bank. You make a deposit and the bank keeps a record of it. It was those records. The other case was a situation where it was about the phone numbers you dialed. So when you pick up let's say you have a landline phone back in the 70s, this is the case out of the 70s, you pick up, again, which shows you how old the technology is that our laws be based on. You pick up a phone and you put in a phone number to dial it and you do the little rotary thing, and that number goes to the Supreme Court said you have no right of privacy in the phone numbers you got, even because you're disclosing them to the company, excuse me. But what's funny about it is, in other contexts, the court has said even if you give something to a third party, you still retain privacy rights. You mentioned a courier. The court, if you think about it, when you give a letter to the postman, you go to the post office and you provide a package or a letter, they can't just go open it. They got to get a search warrant to search it. They can like shake it and decide, something's fishy about this, and maybe they can get enough